I'm Alan Colmes. I want to welcome back to our microphones Congressman Jerry Nadler. He represents New York's 8th Congressional District. He's a senior member of the both the House Judiciary Committee and the House Transportation Committee. He's an attorney as well. Congressman, thank you so much for being with us tonight. Appreciate it very much.
It's a pleasure.
You are upset, as I am, I believe, with the administration's statement that they are saying they can hold detainees even after they have been acquitted. This harkens back to the Bush administration.
Well, yes, although we haven't seen what they mean by it. I hope they have a considerably more narrow meaning than the Bush administration did, but we don't know. And in any event, it's not a good idea.
Why are they doing this, do you think?
Well, I don't know. In general, in many civil liberties areas, this administration has been a surprising disappointment so far, whether it's their insistence on reaffirming, without saying so, but reaffirming in court all the Bush doctrines and the state secrets, which to my mind is one of the two most important areas, or their actions in urging refurbished military tribunals. It's a disappointment. Of course, Congress has gone them one better by doing everything they can to scare people about detainees and to prevent shutting down of Guantanamo, which is one of the administration's best ideas. But nonetheless, they've been very disappointing in a number of areas.
By the way, people should know your district includes Ground Zero, correct?
It does indeed.
So lest one think you just happen to be some random congressman. Maybe the fact is that you have great emotional and personal interest in what this country does in terms of protecting the United States, in terms of terrorism.
I have friends who died at Ground Zero.
That's correct. And the administration, they're saying the laws of war allow indefinite detention to prevent aliens from committing warlike acts in the future.
Well, that is clearly not true. What the laws of war, I mean, if you're talking about preventive detention, you may be talking about two different things which people confuse. One is, let's keep in jail people who we have reason to believe may commit crimes in the future, because we have a crystal ball. That is clearly illegal. There is absolutely no constitutional or legal provision for that, and it would violate all of American legal tradition. In fact, all Anglo-Saxon legal tradition going back to Magna Carta 800 years ago, with the institution of the first habeas corpus rules, which, after all, said to the king, Mr. King, you must give some reason to a neutral magistrate, to some evidence to believe why this person must be held in jail. The other possible reason, though, has some basis, and that is this person is a combatant. He has done something in combat with the United States, and he can be held in order, not because he's committed a crime and not as a punishment, but to prevent them from re-engaging in combat for the duration of the conflict. And that there is basis for, whether he's a prisoner of war or simply an enemy combatant.
The problem is we don't have a defined conflict. We don't have a declaration of war by Congress. The war on terror is a concept. So what conflict are they talking about?
Yes, the war on terror is a concept, and I don't believe that you can define someone for the duration of the war on terror because no one knows what that is or even who the enemy is. Terror is a tool. It's not an identifiable person or group. But we do have a war in Iraq, and we do have a war in Afghanistan. Now, in Afghanistan, when we were fighting the Taliban and they were the governing power, then it was a standard interstate war, and someone captured in that war could be a prisoner of war. Since then, for the last several years, it's been a different kind of war in which it's not two states fighting each other. It's in effect a civil war or an intrastate conflict, and we're battling with insurgents. And you can't call those people prisoners of war, but there is grounding in international law for detaining combatants as combatants. But in any event, the real question, no one doubts that you can hold a combatant during the combat until the end of the war in Iraq or the end of the war in Afghanistan. There are several questions. The chief one of which, though, is it was very easy in World War II when someone was wearing a Wehrmacht uniform and wearing a helmet and holding a rifle and you captured him in Normandy to say he's a prisoner of war. But if someone is not wearing a uniform and you capture him in Afghanistan near a battlefield and he says, I'm not a combatant, I live around here, or I was visiting my cousin or whatever, you have to have some sort of a hearing or some sort of due process to prove that he was a combatant and can be held as a combatant, and that's not clear how we do that.
Now, former military prosecutor Lieutenant Colonel Daryl Vandervelde is an Army reservist from Erie. Told the House Judiciary Committee. Were you part of that committee when he testified?
Yes, I was.
Yes, and you chair that committee, and he said that the whole system is broken beyond repair was the phrase he used in terms of military commissions. Do you agree with that?
Yes, I do. Now, yeah, I do agree with that the military commissions are broken. Essentially, and the facts, just how badly they're broken is shown by the fact that in 7 years they've managed to convict 3 people.
So what do
now,
we do?
We would have done a lot better if we had taken these alleged terrorists and put them before a normal criminal trial.
So what do we do with these people now? Should military commissions be thrown out? Should we do away with that system? And what should happen?
I think the better idea is to do away with military tribunals and to try people either in regular civilian courts for crimes, because these are crimes these are not alleged enemy combatants. These are people who have allegedly committed war crimes of one sort or another. So you either can try them in a regular court, or you can try them in front of a military court-martial if they are alleged to have committed a crime against the law of war. Now, the military tribunal is modeled on the court-martial, but doesn't give as many rights. And the problem with that is that it seems to violate the law. It seems to violate the Constitution. It seems to violate various treaties we've signed. And it doesn't give you reliability in terms of the fact that the verdict meets normal standards, that you can say that if the person is found guilty, he probably is in fact guilty, because they allow the use of coerced testimony, and coerced testimony is inherently unreliable. People will say anything to avoid being tortured or mistreated. They allow hearsay evidence under a lot of circumstances where that evidence is unreliable. Now, some people have suggested that we simply ought to really tighten up the military tribunals and not allow coerced testimony and so forth. And I suppose if you tighten them up enough, they might serve, but in that case, what's the point? You have a court-martial.
We only have about 20 seconds here. What's going to happen?
Well, I don't know. The Senate put in the military authorization bill last week or 2 weeks ago language on military tribunals. The House already passed the bill without that. It would come back to us simply as a conference report, which means an hour of debate on the floor with no amendments. This is sufficiently important stuff that it should be in a separate bill and have proper consideration, not just an hour debate, so we can really debate it and the country can see what we're doing and we can make a decision.
Congressman, thanks much for being with us. Appreciate it very much.
You're quite welcome.